Good morning, I'm Gary DeWaal, and this is Bridging the Week for November 7th to 11th, and today is November 14th, 2016. Last week, Navinder Sarao pleaded guilty to spoofing and proposed to settle his CFTC civil action following his extradition to the United States from the United Kingdom. In addition, ICE Futures US once again proposed revisions to its frequently asked questions related to the possible pre-execution hedging by principals to a futures block trade. And of course, Donald J. Trump won the election to be next U.S. president. It was a surprising week for most last week, and so I can figure out this week what are the implications and what's going on. Let's get started. Navinder Singh Sarao pleaded guilty in a U.S. federal court in Chicago last week to criminal charges brought against him by the U.S. Department of Justice for allegedly engaging in spoofing type activity involving E-mini S&P future contracts traded on the Chicago Mercantile Exchange between April 2010 and April 2015. Simultaneously, the Commodity Futures Trading Commission announced that Mr. Sarao and Nav Sarao Futures Limited PLC, a company he controlled, settled civil charges it had brought against the two defendants related to the same conduct. Mr. Sarao and his company both had been charged by the DOJ and CFTC in April 2016. Afterwards, Mr. Sarao fought extradition to the United States from his home in the United Kingdom, but recently lost his last appeal before the UK High Court. He was physically extradited on November 7th. Among other things, the CFTC and DOJ claimed that Mr. Sarao employed mostly two automated trading programs to implement his illicit trading. The federal regulators allege that he entered numerous spoofing orders, quote, that represented well over 20% of all E-mini sell orders visible to the market, end of quote, in E-mini S&P futures on May 6, 2016, the day of the so-called flash crash. To resolve his CFTC charges, Mr. Sarao proposed to disgorge profits of over $12.87 million US and pay a fine of over $25.74 million US, among other sanctions. The U.S. Federal Court in Chicago must formally approve the CFTC settlement. A status hearing on Mr. Sarao's criminal action is scheduled for February 9, 2017, while Mr. Sarao and the CFTC are formally scheduled to present his settlement agreement to the court for its approval this week. ICE Futures US proposed amending its frequently asked questions regarding pre-hedging futures block trades less than 2 weeks after its latest guidance became effective on November 1st. IFAS's current block trade FAQ permits certain pre- or anticipatory hedging by a counterparty to a potential block trade prior to the block transaction being formally executed. However, this ability does not exist for, quote, an intermediary that takes the opposite side of its own customer order, end of quote. In addition, currently it is prohibited under the IFAS guidance for a person to engage in front-running of a block trade when acting on material non-public information regarding an impending transaction by another person, quote, obtained through a confidential employee-employer relationship, broker-customer relationship, or in breach of a fiduciary responsibility, end of quote. As proposed to be amended, the phrase fiduciary responsibility would be replaced by the phrase, quote, pre-existing duty, end of quote. It appears the new phrase is broader than the prior phrase, although it is not clear what is contemplated by the new phrase or that it has any applicability in connection with principal transaction. Absent objection by the Commodity Futures Trading Commission, IFAS's new FAQ should be effective November 28th. As I said here last week, the Commodity Futures Trading Commission on November 4th approved a supplemental notice of proposed rulemaking regarding regulation automated trading initially proposed during November 2015. The supplemental proposal includes a volumetric threshold designed to reduce the potential number of possible AT persons, a change to the definition of direct electronic access, a new process for the CFTC to request access to source code through special calls, and a methodology for AT persons to delegate somewhat the process to conduct algorithmic trading system testing to third parties that control such systems. In thinking about the proposed supplemental rules, a couple of aspects of the volumetric test may require drafting revisions to help ensure the reduction of proposed persons likely most impacted by Regulation AT from substantially over 420 persons to less than 120 persons actually occurs. Check out the article version of Bridging the Week for my views. Finally, for insight into my views on the impact of President-elect Trump's impact on financial services regulation in the U.S., also check out the article version of Bridging the Week. I know he says he wants to repeal the Dodd-Frank Wall Street Reform and Consumer Protection Act, including the Volcker Rule, but is that possible or even consistent with other statements he has made publicly and is now including on his new President-elect www site? Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more article on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.